So the next presenter that we're fortunate enough to have today is Shona Senior. Now, all of the presenters that I've helped to organise with this set of presentations, we're all members of a special interest group committee that's somewhat associated with the local branch of the New Zealand Law Society. And Shona was integral to setting up this, the elder law special interest group and to making sure that it continues. And I think that's a real testament to Shona's commitment to working in this space and trying to better herself and the rest of the profession in it. And so Shona is a genuine specialist when it comes to elder law and these sorts of matters. Today, Shona is going to talk about trading places. And that will make complete sense as she starts to speak. So I'll pass it on to you, Shona.
Thank you, Sonny. Today my presentation is about trading places, and it talks about older people's move from their own home into some form of residential care. Statistically, at age 65, about 5% of the population is in care. At age 85, that number increases to 21% of the population. And of those aged 85 and over, the average stay in a rest home care is 18 months. Most people don't like to hear that statistic. It's also interesting to note that about 54% of the population aged over 85 will die in care. And that is mainly because of the number of people who end up in respite care for one reason or another. Next screen, if we can, Sonny, thank you. There are different types of retirement village living. The first one is an actual retirement village where people can live independently or semi-independently in a villa or apartment. The resident purchases a right to occupy, and the terms set out in an occupation rights agreement, or ORA, between the resident and the retirement village, set out the rules of the village and the fees to be paid. These are guided by legislation. The resident also pays a monthly fee for maintenance of the village, which usually covers the exterior of the building, the grounds, common areas, and some services. There is no government funding for this level of care. Next screen, thank you. The next level of care is residential care, and this is supported or hospital level care, and is most commonly recognised as rest home level care. The resident enters into an age-related residential care contract between the DHB and the rest home operator for the provision of age-related residential care services. The government sets a standard fee for basic services, which in Christchurch at the moment is about $1,005 a week. It does vary by location, with Auckland being considerably more expensive than, say, Invercargill. The resident pays additional fees for extra services, such as large rooms and extra care. There are government subsidies available, and these are based on needs, assets, and income tests. The first is a needs test. The person needs to require long-term residential care in a rest home or hospital, and they need to be aged 65 years or over. Under 65, a different set of rules apply. The asset test is a little bit more confusing, and the figures vary each year. They are altered, they are updated on the 1st of July each year, so I'm working on figures as at the 1st of July 2018. If you're a single person or have a partner in care, the total value of combined assets must be less than $227,125. If your partner is not in care, then the total value of combined assets can be either $124,000 plus the value of the house and the car, or $227,125, including the value of the house or car. People who are asset rich and cash poor can often qualify for under the asset test because of the value of the house, which is often the main asset. The house is only exempt when it is the principal place of residence for the partner who is not in care or a dependent child. The third test is an income test. So if you qualify under the asset test, you also need to prove that you don't have assets, or if you're single, of more than $992 per year, or $1,983 per year if you're a couple and both in care, or $2,975 per couple if only one is in care. Any income over those amounts can be applied to residential care costs. It doesn't allow for very much income over and above a pension. Income from a trust or any other source that is stopped when the person goes into care may be considered deprived income and may be counted back into the asset pool, even if the resident is no longer receiving it. So you do need to be very careful when looking at residential care subsidies and eligibility. And what we note is that quite often when we're asked to review a rejected application for residential care, that the forms haven't been filled out correctly, and that when completed correctly, the person may actually qualify. So it is really worth the person making the application getting somebody with the correct knowledge to check the application before they file it. That's the basic outline of the test for residential care subsidies. Now I want to go on to a couple of issues that arise when you're considering residential care subsidy applications. And the first one is gifting. Now, a lot of your customer clients will have been gifting to trusts or perhaps making gifts to family members over a number of years. What you need to be aware of is that in the 5 years prior to going into care, the maximum amount that a person can gift is $6,000 per annum. So that requires older people and their advisors to do some crystal ball gazing and guess when that older person might need residential care and plan to reduce or stop the gifting if it's going to impact on residential care subsidy eligibility. There is no magic answer, and what we often recommend to clients is that they start reducing their gifting well out from their possible need for residential care. Family trusts can create some curveballs when looking at residential care subsidies. And also, we have a number of quite large numbers of elderly clients who 20, 30 years ago put their home in a family trust to get around residential care subsidies. They're now finding that, in fact, in most cases, that plan hasn't worked, and they now have to consider whether they want to keep the family trust or whether they are going to wind it up and how they're going to distribute the assets in the trust. That takes quite a wide consideration of the person's situation and possible implications of winding up the trust. It shouldn't be, winding up of the trust shouldn't be done without a very considered thought. Where people do decide to keep their family trust and sell the home to purchase an occupation rights agreement or an occupation license, they have a little bit of a problem because an occupation license cannot be purchased by the trust. It needs to be purchased by the resident. So there needs to be some sort of agreement between the family trust